Thank you everyone for joining us this morning. I'm Nikki Jovicic from LookUpStrata. Welcome to today's webinar, Pets in Strata. We're joined today by Adrian Mueller from JS Mueller Co Lawyers. A copy of the recording of this webinar will be available later today, so stand by your inbox for the email. While I have you here, I'd just like to mention our New South Wales magazines. These are packed full of specifically New South Wales articles and Q&As and include content that does not appear in our national Monday and Wednesday newsletters. If you haven't yet seen the New South Wales Strata magazine, I'll place a link in the chat soon. Before we begin, I'd like to mention that the information contained in this session, including the discussions that arise from submitted questions, is not legal advice and should not be relied upon as legal advice. You should seek independent legal advice before acting on the information contained in this session. During the presentation, I'll be moderating the chat, so please say hi. If you'd like to participate in the chat, just click the drop down directly above your comment and select the option All Panelists and Attendees, and that way everyone can see your comments. Thank you to everyone who submitted questions before this event. Due to the number of questions received, I'm not sure how many Q&As we'll be able to respond to today. We have quite a bit of content to cover, so we'll get through as much as possible. I'll be handing over to Adrian shortly to give a history of the events leading up to the current state of pets in strata in New South Wales, and this will be followed by the Q&A session. I'm very mindful of the amount of information we have, so let's get started. I'm delighted to introduce Adrian Mueller from JS Mueller Co Lawyers. Adrian is widely regarded as one of the country's leading strata lawyers. He's renowned for having an outstanding grasp of all aspects of strata law and for providing well-written, detailed and easily understandable legal advice. At the forefront of strata law, Adrian has delivered a number of groundbreaking papers to strata lawyers at seminars across New South Wales and Queensland. He's also lectured extensively on a range of strata law topics. In recognition of his expertise, Adrian is the youngest person to have been admitted as a Fellow of the Australian College of Strata Lawyers. Adrian and his team at JS Mueller Co Lawyers are also regular contributors to the LookUpStrata blog. And this isn't the first Strata video Adrian has recorded with LookUpStrata. Way back in 2016, just before the New South Wales reforms came in, Adrian joined us for a video on how the strata reforms were going to impact lot owners' lives. That video received some excellent feedback from the LookUpStrata audience and has had over 2,500 views. And Adrian is breaking records again here today with over 300 registrations to this event. This is the largest audience we have had registered for one of our webinars. Welcome, Adrian. I'll hand over to you now.
Thank you, Nikki. I'm delighted to be here. The hottest topic in strata in New South Wales at the moment is pets. And what I propose to do during our seminar this morning is explain why that's so. And in order to do that, I really need to take a journey back in time with our audience, which starts in 1997, and explain what has occurred since then and why in 2021, pets in strata in New South Wales has become the hottest topic. So our journey begins in 1997, when in New South Wales, the strata laws were rewritten. And at the time, the New South Wales government introduced a new set of model bylaws. And those model bylaws included a new pets bylaw that contained 3 different options that could be selected by any strata building. One of those options was a no pets option. And so it was possible for a strata building to adopt a bylaw that imposed a blanket ban on pets. And over the last 25 or so years, there have been many strata buildings in Sydney and throughout New South Wales that have adopted no pets bylaws. And it was generally accepted that no pets bylaws were perfectly permissible, and it was possible for owners to have pet-free buildings. We then moved forward to 2016, when the New South Wales government again decided to rewrite the strata laws. And what happened in 2016 is that the new strata laws in New South Wales placed some new restrictions on the bylaw making power of owners, corporations and developers. And importantly, those restrictions said that a bylaw couldn't be harsh, unconscionable, or oppressive, and gave the Civil and Administrative Tribunal in New South Wales the power to overturn any bylaws that fell foul of that restriction. Most people in the strata industry were unclear or uncertain on how that restriction would play out in practice. And it really didn't take long for NCAT to have to come to grips with it. And everything seemed to change in February 2018 when NCAT decided the Yardy case. And the Yardy case involved a couple, Mr. and Mrs. Yardy, who moved into a strata building in Sydney with their pet rescue dog, Baxter. And the Yardys went to have a look at the apartment in this building, had a look at the notice board. The notice board contained the bylaws for the building, and those bylaws indicated that you could keep pets in the building if you got strata approval to do so. Well, unbeknownst to the Yardys, the Owners Corporation had in fact changed that bylaw to prohibit pets in the building, and the bylaw displayed on the notice board was old. So the Yardys went ahead, they bought their apartment, and they moved Baxter into the apartment with them. And not long afterwards, they were told by the Owners Corporation that it was a pet-free building and that Baxter wasn't allowed to stay. Needless to say, they weren't impressed. They appealed to the Owners Corporation to change the No Pets bylaw and to introduce a more pet-friendly version of that bylaw. But the Owners Corporation decided not to do so. The majority of owners simply didn't want pets in the building. So off the Yardys went to NCAT, and they sought an order overturning the No Pets bylaw on the basis that the bylaw is harsh and that it is unenforceable. And the Yardys were successful. And in February of 2018, NCAT made a ruling overturning the No Pets bylaw in that case. That was a watershed moment in strata law in New South Wales. It was the first time that a No Pets bylaw had been overturned by NCAT. What then happened was that in the second half of 2019, there were a series of cases decided by NCAT in which it was held that No Pets bylaws are invalid because they are harsh. And those cases involved two very large apartment buildings in central Sydney, one known as the Horizon building in Darlinghurst, which is a fairly famous Harry Seidler designed building in Sydney's inner eastern suburbs. Order was restored in May of last year because the appeal panel of NCAT overruled all of those previous decisions and said it was possible to have a No Pets bylaw and there was nothing wrong with doing so. Everyone thought, well, that's the way it's always been, order has been restored. But Mr. and Mrs. Cooper, who owned an apartment in the Horizon building, weren't satisfied with that decision. So they decided to take that decision to the highest court in New South Wales. And the reason they did that was because they wanted to be able to keep their miniature schnauzer, Angus, with them in their apartment in Horizon. But the problem they faced was that the Horizon building had a No Pets bylaw. And Mr. and Mrs. Cooper had moved Angus into their apartment in Horizon, knowing that there was a No Pets bylaw, and everything had been okay for a couple of years, but ultimately the Owners Corporation decided that it should enforce the bylaw, and the dispute wound up in NCAT. In any event, the Coopers took the case to the highest court in the state, and to the surprise of some in the strata industry in New South Wales, the Court of Appeal decided that the No Pets bylaw in the Horizon building was invalid and not enforceable, as a result of which the Coopers were allowed to keep Angus in their apartment with them. And it was a big victory for pet lovers and people who think that pets should be allowed to live in strata buildings in New South Wales. What I now want to spend a little bit of time talking about is the reasons why the court in the Cooper case decided that a No Pets bylaw in the Horizon building is not enforceable. To sum up the court's reasoning in a nutshell, what the court said was that a no pets bylaw goes too far because it bans pets that could not possibly have a detrimental impact on other residents in the building. And the court gave the example of a goldfish in a bowl kept on a desk in an apartment, or a small caged bird kept in an apartment. And the court said rhetorically, well, how could a pet like that have any detrimental impact on other residents? And why should an owners corporation be allowed to make a bylaw that bans pets like that? The court really considered two key aspects of the no pets bylaw in the Horizon building. The court looked at the power an owners corporation has to make bylaws, and then it looked at that new restriction I mentioned a moment ago, that bylaws can't be harsh, unconscionable, or oppressive. And turning to the first issue, what the court said was this, that the power to make bylaws is not unlimited. There are some things bylaws simply can't do. And a bylaw has to be for the benefit of owners in the strata building. Now, the court said that a bylaw could deal with activities that may adversely affect the amenity of other residents in the building. But a bylaw that restricts the right of residents or owners to use their apartments in a way that would not interfere with the enjoyment of other apartments is not for the benefit of owners and is beyond the power that an owners corporation has to make bylaws. So for that reason, the court said, well, a no pets bylaw doesn't provide a benefit to all of the owners because it goes too far and it bans certain types of pets that could not possibly have a detrimental impact on the amenity of other residents in the building. So strike one, there's no power to make a bylaw banning pets. The court then looked at the new restriction on bylaws. In other words, bylaws can't be harsh. The court said that the expression harsh or unconscionable doesn't really have a clear meaning, but the court should apply contemporary community standards about what is just when it tries to interpret what the legislation means when it says you can't make a bylaw that's harsh, unconscionable, or oppressive. What the court then said was that the right to live with a pet in your home is a property right. If I buy an apartment in a strata building, I own that piece of land or that apartment. That carries with it certain property rights, one of which is the right to own and keep a pet in my home. The court then said that a bylaw can prevent you from enjoying a property right when you live in your apartment. But importantly, the court said that the bylaw must provide a benefit to other owners and it must enhance the enjoyment or amenity of their lots. The court went on to say that a bylaw that restricts an owner from enjoying those property rights, such as the right to keep a pet in their apartment, is harsh where the restriction doesn't benefit other owners or preserve the amenity of their apartments. And the court came back to the conclusion that I discussed earlier, that a bylaw imposing a blanket ban on all pets is harsh because not all pets can possibly have a material impact on the amenity of other apartments in the building. So it was for those reasons that the court said the no pets bylaw is not enforceable and Mr. and Mrs. Cooper are allowed to keep Angus in the apartment with them. The court then had to deal with a couple of arguments that the owners corporation raised. And these arguments are quite important because a number of the questions that our LookUpStrata subscribers have sent us deal with these issues. So what the owners corporation of Horizon said is this: we should be able to have a bylaw banning pets. Otherwise, we will be placed under an administrative burden that will be impossible for us to manage. Why? Because firstly, we will become inundated with applications by residents to keep pets. And we simply just don't have the time or the resources to deal with all of those pet applications. And secondly, the Owners Corporation said that we don't want people to be able to challenge our decisions. So if we're forced to have a bylaw that requires people to apply for permission to keep pets, and we reject pet applications, those people will be able to challenge our decisions in NCAT. And we don't want that to happen. What the court's response to that argument was as follows. It said, look, the strata committee of any strata building is required to make evaluative judgments. It's an inescapable ingredient of strata living. For example, almost on a weekly or monthly basis, many strata committees have to make evaluative judgments about whether other bylaws are being breached, whether residents are parking on the common property in breach of the parking bylaw, or making too much noise in breach of the noise bylaw. And that's just something that the strata committee has to do. It's part of its job to make those evaluative judgments. The court also said that regulating the behaviour of people who live in close proximity to each other in a strata building requires a degree of regulation by bylaws, and that will involve the strata committee and owners corporation making evaluative judgments from time to time to assess whether those bylaws have been breached. So a committee can't say, we want a no pets bylaw because we just don't want to have to deal with pet applications. It's just not on. And the court also observed that having a blanket ban on pets operates arbitrarily, and it produces an injustice in some cases. Why? Because it doesn't allow an owners corporation to consider a particular person's special circumstances when it may well be appropriate for that person to be allowed to keep a pet in a strata building. And the court also said that this notion that having a blanket ban on pets would create administrative convenience is a bit of a furphy. Why? Because they gave this example. In the sphere of the criminal law, fixed sentences for crimes would no doubt save courts time and money, but would produce unjust outcomes. If the criminal law was changed to say, you steal a loaf of bread and you automatically go to jail for 5 years, well, that would produce an unjust outcome. So the court was saying, well, you can't do the same things with pets and ban them across the board and say, no one can keep a pet, no matter what your circumstances, and no matter how inoffensive that pet might be. The court also dealt with the owners corporation's argument that allowing pets would open the floodgates and that the building would become inundated with nuisance pets. The court's response to that argument was to give it a bit of short shrift and to say, look, there are model pets bylaws and provisions in the strata legislation which adequately deal with nuisance pets. That if there are barking dogs living in your strata building, there are things you can do about that to get rid of those dogs if necessary. And the last argument the court had to deal with was the notion that shouldn't the democratic will of the overwhelming majority of owners prevail? So in the case of the Horizon building, there was some evidence that about 90% of owners wanted the building to remain a pet-free building. And so the argument was, well, if 90% of owners want a pet-free building, why shouldn't we be allowed to keep it that way? And the court's answer to that was an interesting one. It said that a democracy is not a majoritarian dictatorship. Just because the majority wants something to happen doesn't mean it should be allowed to happen. That the decisions that are made by a majority in a strata building operate under legal constraints that are designed to protect minorities from oppression. And ever since November 2016, harsh bylaws have not been allowed. And so the court's view was that a blanket ban on pets was harsh. It didn't matter that 90% of owners wanted it. It wouldn't have mattered if 99% of owners wanted it. the democratic will of the overwhelming majority has to yield to the legal constraints that are imposed on the decision-making powers of an owner's corporation to ensure that the interests of minority owners are protected. So where does that leave us? Well, it means that the way matters stand, no pets bylaws, that is, bylaws that ban all types of pets from a strata building, are not enforceable and are not valid. And that then means there are some important consequences for all strata buildings, particularly residential strata buildings in New South Wales. And I think that there are 5 lessons that we can all learn from the outcome of the case. The first lesson is, if you live in a strata building, check your bylaws and see what your pets bylaw says. If you have lesson 2, a no pets bylaw, you have to realise that that bylaw is not enforceable. The third lesson, and this is really important, is that if you have a building that contains a no pets bylaw, you have to realise that your building does not have any valid bylaw dealing with pets. Now, if we just pause here for a moment, I've given advice to many strata buildings across New South Wales since this court decision came out in October. And the anecdotal evidence is suggesting that there are lots of strata committees that are either burying their heads in the sand or trying to call the bluff of owners and tenants who want to move pets into the building when the building has a no pets bylaw. And the advice I'm giving my clients is that it's a mistake to do that. And the reason for that is quite simple. And this is the 4th lesson we need to take from this case. If you have a building that has a no pets bylaw, because that bylaw is not valid, it means that people can bring pets into your building without having to obtain strata approval to do so. So you've got this no pets bylaw, which is not worth the paper it's printed on. People who live in your building can bring pets into that building without having to ask your owner's corporation for approval to do so. And that then gets us to our 5th and final lesson, and that's this. Once that occurs, once somebody moves a pet into a so-called no pets building, it's going to be very difficult for the owner's corporation to get rid of that pet. And it will only be possible for the owner's corporation to get rid of that pet if it creates a nuisance or it unreasonably interferes with the amenity of other residents. So the strata committees out there who are burying their heads in the sand or trying to bluff their way through this are, in layman's speak, cruising for a bruising, because if someone moves a pet into their building, they may well have difficulty getting rid of that pet. So that begs the obvious question, Nikki, what should owners' corporations of strata buildings who have no pets bylaws do? And the answer to that question is you should replace your no pets bylaw ASAP. And how do you do that? Well, you need to have an appropriately drafted replacement bylaw prepared, call a general meeting and put it to a vote, and it needs to be approved by a special resolution, which is a 75% majority based on the pool of votes calculated on unit entitlements. Okay, that's great, but what should the replacement bylaw say? Well, this depends on whether the owners in your building want to allow pets or want to still place restrictions on pets. Assuming that most buildings that are currently so-called pet-free buildings want to place restrictions on pets, then the replacement pets bylaw should do these things. 1, it should require owners and tenants to apply for strata permission to keep pets in the building. 2, it should prevent an owners corporation or strata committee unreasonably withholding approval of an application to keep pets. And 3, the bylaw should impose reasonable conditions regulating the keeping of pets in the building. What do I mean by that? Well, the bylaw, for example, should require pet owners to register their pets with the owners' corporation and the local council before moving them into the building, particularly in the case of cats and dogs. I don't think we're registering fish. The bylaw should place controls on the way pets are brought into and out of the building. So, for example, in the case of dogs, it should require the dogs to either be carried or kept on a lead when on the common property. It should require the pets to be kept inside the apartments and not left on the common property. There are some owners' corporations that are imposing restrictions on keeping pets on balconies, courtyards, and other outdoor areas. The bylaw should ensure that pets don't create a nuisance or disturb the peaceful enjoyment of other residents, and give the owners' corporation the right to deal with that issue if it arises. And the bylaw should also deal with issues like preventing pets causing damage to the common property, restricting areas of the building where pets can enter and remain, such as a swimming pool area, a gymnasium, etc. What people need to realise is that there has been a marked shift in the law. And for 25 years, people in the strata industry have become accustomed to no pets bylaws, and things have changed. The court decision in October last year means that no pets bylaws are no longer enforceable. In my view, that position is now beyond doubt. And that means that if your building has a no pets bylaw, you need to do something about it. Sitting on your hands is not going to help you address the problem created by pets being brought into your building. It will only make it worse and more difficult for you to deal with it, should that situation arise. So that's the state of play at the moment, Nikki. No pets bylaws are out. Pets are in, although we can still put restrictions on the rights of people to bring pets into our strata buildings. And in some cases, we are still allowed to say no and to prevent people bringing pets to live with them in their apartments.
Okay, thank you for that summary, Adrian. That was quite complicated, because the situation is quite complicated. Now we have, as you mentioned, we've had quite a few questions come in from our audience prior to the event today, and we have collated some of those together because there were some similar questions that came in. So thank you for doing that. And we'll just read through them now. You have addressed some of the issues during the short discussion that we've just had there, but we will go through them. And then we've had some questions come in. So if we've got time at the end, we will jump back to the questions, but we'll just stick to the ones that came in to begin with. So are you ready to go ahead now?
Let's shoot, Nikki.
Okay, here we go. Our strata have a bylaw which does not permit pets with the exception of assistance animals such as a guide and hearing dog. Is this bylaw acceptable?
The answer to that question is crystal clear: no. A bylaw which bans pets except assistance animals is not acceptable. It's not enforceable. It's not worth the paper it's printed on.
Okay, so the second part of that same question was, if the no pets bylaw is not acceptable, what should we do?
And the answer to that question is equally clear, Nikki. You should replace that bylaw with an appropriately worded bylaw that places restrictions on the right of owners and tenants to keep pets in your building and contains reasonable conditions that regulate the keeping of pets in the building. And we went through that towards the end of the discussion a moment ago.
Okay. Why should owners who select a no pets bylaw have their decision overturned?
This is a really good question, and it was dealt with by the court in the Cooper case. And there are many people out there who think they should be masters of their own destiny. So they should be able to decide whether their building will allow pets or be pet-free. But what you have to realise is that there are laws that place constraints on the ability of an owner's corporation to make bylaws, including pets bylaws. And what the court has said is that those constraints make it impossible to have bylaws that impose blanket bans on pets. And that in the words of the court, the democratic will of the majority of owners doesn't convert a democracy into a majoritarian dictatorship. So the court was sending a message to owners in Strata land in New South Wales that even though you might want something, what you want in the eyes of the law is unreasonable, and therefore you just can't have it.
Okay. The next one is a bylaw that bans dogs but allows other animals legal. And we've had this come up quite a bit in the discussion as well today. So, hot topic.
So that's a really good question. And I think there are a number of strata buildings that are looking at doing something like that. So they want to replace their blanket ban on pets with a blanket ban on dogs or certain other types of animals. And in my view, you can't do that. You cannot impose a blanket ban on dogs. And the reason why you can't do that is because that bylaw goes too far. Because there are some dogs that can be kept in an apartment building that will not have a detrimental impact on the amenity of other residents. So imposing a blanket ban on all dogs is a form of overreaching. And the court said you just can't do that. So what the New South Wales government has done in response to this court decision is pass some new strata laws that will commence later this year. And one of those new strata laws says that you can ban the keeping of pets, provided that the ban is reasonable. So what that means is that, for example, you can have a bylaw that says you are not allowed to keep fighting or dangerous dogs in our building, because that's reasonable. Because fighting and dangerous dogs will have a detrimental impact on the amenity of other residents because they're going to attack them. So you should be allowed to ban them. But what you can't do is just put a blanket ban on all dogs or all cats or all hamsters and guinea pigs and fish and the like. If you can think of certain exotic pets that someone might want to keep in your building that are definitely going to have a detrimental impact on others, let's take a simple example, venomous snakes that may well be let loose. No one wants venomous snakes in their building. Can you have a ban on venomous snakes? Possibly. However, what happens if you have a very responsible pet owner who says it's legal for me to keep a venomous snake in my apartment, provided it's in a certain enclosure, which I promise to maintain. I'll never open the enclosure. The snake will never get out. So you can see an argument going both ways there. And NCAT may well say that a bylaw banning dangerous snakes that could possibly be kept in the building in a way that doesn't have a detrimental effect on anyone is not valid. But that's a debate to be had for a later day.
Okay, and just on that same topic, we've just had a question come in stating, can we limit to domestic animals? That would avoid goats and sheep in most cases.
So I think the question is this is the touchstone. When you ask yourself, can we ban a particular type of animal? The answer to that question will depend on whether it's possible for that particular type of animal to be kept in your building in a way that does not have a detrimental impact on others. If the answer is yes, then you can't ban it. If the answer is no, then you can ban it. So if it's not possible to keep sheep and goats in a residential apartment building in Sydney in a way that does not have a detrimental effect on other residents, and I think it probably is impossible, then yeah, I think you can ban them. But of course, you've got to ask the obvious question, who's going to want to keep a sheep or a goat in an apartment building in Sydney? But hey, it's strata land, so we see all sorts of weird and wacky things.
Now, I did think this question was quite interesting. Why has no one used the argument that their pre-2016 pets bylaw remains valid due to the Schedule 3 transitional provisions of the Act?
So that's a technical lawyer's question. I suppose we have a few bush lawyers out there watching, so let me do my best to answer it. when the New South Wales government rewrote the strata laws that commenced in November 2016, there was a provision which said that if there is a pre-existing bylaw that was valid at the time it was made, it remains a valid bylaw no matter what we say in these new laws. So the question is this: if it was possible to make a no pets bylaw prior to 2016, why didn't some smarty pants run that argument in the Court of Appeal and say, Your Honours, we were able to make a no pets bylaw in 1997. This transitional provision in the new strata laws say that if the bylaw was valid back then, it's still a valid bylaw. How can you overturn it? Now, the court's answer to that question, even though it didn't directly arise in the case, was this: you never had the power to make a no pets bylaw. Now, that was quite a surprising position for the court to take, but in effect, what the court was saying was that the no pets model bylaw that was introduced in 1997 wasn't valid. Now, that'll leave a lot of people scratching their head. How can the government make a model bylaw that's not valid? Well, it's possible. Courts have the power to and do set aside legislation and regulations that are made by the government or Parliament from time to time. And I guess that's what the court was saying, that you've never had power to make a no pets bylaw. So that transitional provision doesn't help you.
Very interesting. Do the new laws affect how we manage residents with pets, such as the issue of barking dogs, the safety of other residents, and ensuring the pets do not dirty common areas?
I think the answer to that question is yes, because if you have a no pets bylaw, then you have no rules dealing with these problems that can be created by pets. So you need to change that bylaw to put in place a bylaw that does contain rules to deal with barking dogs, the safety of residents, and ensuring pets don't dirty common property. And you need to act sooner rather than later before people start moving pets into that building.
How does the strata deal with barking dogs or a barking dog that is upsetting the tranquility of the residents when the dog owner does nothing to stop the barking?
I think it's steps and stairs. So the first thing is that the dog owner should be spoken to or written to. The problem the dog is creating should be put to that owner, and the owner should be asked to address it. You have to remember that some people go to work, leave their dogs at home, don't realise the dog is barking during the day, only to come home and find people complaining about it. So speak to or write to the owner of the dog and ask them to do something about the problem. If that doesn't work, then you would typically have your strata manager write to the owner of the dog, explain the problem and ask them to deal with it. If that doesn't work, you then get to the sort of step 3, which is to issue a notice to comply with the pets bylaw or other bylaws on that owner. And if that doesn't work, step 4 would be to go to New South Wales Fair Trading to have a mediation to try and resolve the dispute with the owner of the dog. And if that doesn't work, your final step and port of call is to go to NCAT to seek an order for either the dog to be removed or to compel the owner to take steps to stop the dog barking.
Should there be the provision for tougher penalties for the residents who do not comply with bylaws for responsible animal ownership?
I think there should, Nikki, and that's a very topical question, because at the moment, NCAT only has the power to impose a $1,100 penalty on a pet owner who contravenes a notice to comply with the bylaw. And there are many pet owners that would be prepared to pay that price to keep their beloved dog or cat in their apartment with them. What the new laws the New South Wales government has just passed will say when they become law later this year is that NCAT will have power to impose a $5,500 penalty on any person who breaches an NCAT order. So that means that if an owner's corporation takes a dog owner to NCAT, gets an order for the dog to be removed from the building because the dog is causing a nuisance, and the owner doesn't comply with that order, the owner's corporation can go back to NCAT and have that dog owner penalised up to $5,500. I think we all have to ask ourselves the question, what price are some people prepared to pay to keep their beloved dog or cat in their apartment with them? And I dare say that there are lots of people that will be prepared to pay a penalty of that magnitude. So I suspect the answer to the question is yes, there should be tougher penalties imposed on people who breach the bylaws dealing with keeping of pets, to provide them with a sufficient incentive to comply with those bylaws and orders that are made by UCAT.
And we've had this question come in from quite a few of our readers as well. What constitutes a pet? I've heard of people owning reptiles like snakes as pets.
So most of these bylaws deal with animals, and an animal is pretty much anything under the sun. And it's probably better for a bylaw to talk about animals rather than pets, so that we don't have to get into a debate about whether the particular type of animal that Mr. Smith wants to bring in the building is or is not a pet. If your bylaw deals with animals, then when Mr. Smith wants to bizarrely bring his pet goat into the building, you can say, sorry, our bylaw either doesn't allow goats or requires you to get our permission to keep a goat, and we're not going to give you that permission because there's a reasonable basis for us to withhold that permission. That's the way that problem should be dealt with, so we don't have to get into a debate about is that animal a pet that's covered by our bylaw. Okay,
and if we can just jump back to the previous question, if you don't mind, about the harsher penalties for not complying with the bylaws. We've just had a question come in on that, which was there's so many questions coming in. What if they pay the fine and keep the pet without complying? Can they be fined again?
So they can be fined again. At the moment, it's not clear what the extra penalty can be. If the $1,100 fine is imposed on the owner for breaching a notice to comply, and the owner continues to breach the relevant bylaw, you can go back to NCAT to get a penalty of up to $2,200 imposed for a repeat offence. What's not clear, however, is how the new laws I spoke about earlier are going to work. Those are the laws that will give NCAT power to impose a $5,500 penalty for a breach of its orders. So you go the extra mile, you take somebody to NCAT, you get an order for them to remove their barking dog from the building, they ignore the order, you go back to NCAT again, incurring more time and costs, you get a penalty imposed. It probably won't be the maximum of $5,500 because that's reserved for the most serious cases, and still nothing happens. And still you have to put up with the barking dog every day and night. What can you do? And it's not clear under these new laws whether you'll be able to go back to NCAT and seek a further penalty. I suspect the answer is it will be possible for you to do that. The maximum penalty for a repeat offence will still be $5,500, but I dare say NCAT would be inclined to probably impose a more severe penalty on a repeat offender. But the question, of course, remains, Nikki, is that more severe penalty going to be enough to get rid of the problem?
Is it possible to ask pet owners to pay a bond to the Owners Corporation to cover any costs incurred by Strata as a result of their pets or them breaking the rules?
The answer to that question is yes. I've drafted many pets bylaws that require pet owners to pay a bond to the Owners Corporation before moving their pet into the building. The bond then gets held by the Owners Corporation until the pet leaves the building permanently, such as when the tenant's lease expires or the owner sells their apartment. And the bylaw allows the Owners Corporation to use that bond to cover the costs it might incur cleaning areas of the common property that are soiled by the animal or repairing damage caused by the animal.
And is that a fairly common request, Adrian, or do most people not know that that's available?
It's becoming increasingly common. And I think as people start to realise that no pets bylaws are no longer enforceable, it will become more common and more prevalent. It really started in renovations bylaws, where you saw requirements for renovators to pay bonds to owners' corporations before starting work. And that has filtered into other bylaws. For example, bylaws regulating moving into and out of the building when people will often damage lift doors and the like when they're moving furniture and other large objects. And now the requirement for payment of a bond is starting to filter its way into pets bylaws.
And just on that point as well, one of the questions that has come in is you refer to owners, but what about tenants? And that would be applicable here as well.
It would, Nikki. So bylaws bind owners and tenants, and there's no reason why a bylaw can't say that a tenant, for example, has to pay a bond to the owners' corporation before moving a pet into the building, if they're allowed to do so. There have been some questions coming through on our chat about the rights of landlords to stop tenants keeping pets. And that's a separate issue to what we've been discussing. But just to address it very briefly, under residential tenancy laws in New South Wales, landlords are entitled to prevent their tenants keeping pets in the strata building. So that can, in some cases, overcome the problem that the court case has created for owners that want to live in pet-free buildings. And I gave an owners corporation in Sydney advice recently about their no pets bylaw, and it was all doom and gloom from me. Your bylaw is not worth the paper it's printed on. You need to change it. You need to deal with this tenant who wants to move a dog into the building. And of course, my advice didn't go down particularly well because the Strata committee wasn't particularly happy about being told that their no pets bylaw was no good. But what did emerge was that the owner of that apartment didn't want dogs or any pets to be kept in it, like many landlords. And under the residential tenancies legislation in New South Wales, that owner was perfectly entitled to say to his tenant, no pets allowed. And that then was a neat way to deal with the problem. And the Strata committee was very relieved when they discovered that this owner was on their side and didn't want pets in their apartment.
Okay. Is the new bylaw to permit animals to be kept allowed to restrict the size of dog? Now, this is something that's come up quite a bit in the chat today as well. So allowed to restrict the size of one dog only to 10 kilograms and under, and require the dog and any other permitted pet to be carried while on common property, either in arms of the occupant or caged if a cat or other animal.
So it's a double-barrel question. Let me address the second aspect of it. Can you put in place a bylaw that says if you've got a cat or a dog, you've either got to carry it when it's on the common property or put it in a cage, or in the case of larger animals, make sure they're tethered to a leash? The answer is yes, provided it's reasonable to do that in your building. And in most buildings, it would be reasonable. The first limb of that question, however, is a bit more tricky. Can you have a bylaw that says you are not allowed to keep large dogs in our building? For example, a dog that weighs, or when fully grown will weigh, more than 10 or 15 kilos. My answer to that question is no, it's not possible to do that. And if you do that, that aspect of your bylaw will not be enforceable. Why? Because if we go back to what the court said, it may well be possible for someone to keep a large dog in your building in a way that doesn't have a detrimental impact on the amenity of other residents. And for that reason, owners and tenants should at least have the right to apply to their owners' corporation for permission to keep the large dog. And the owners' corporation or the committee can then assess that application on its merits, deal with it reasonably, and decide yay or nay. Now, can we just digress for a brief moment? This is probably going to be the next hot topic in this area. What we're going to see are a lot of bylaws that say, if you want to keep a pet in our building, you need to get our approval. And a lot of those bylaws will go on to say, as they need to do now, we can't unreasonably withhold that approval. So what does that mean? It means that if your strata committee is confronted with an application by an owner or a tenant to keep a pet, and they want to say no, because, for example, someone wants to bring a Great Dane into the building, a large dog, and everyone's concerned, or the committee is concerned, that the Great Dane is going to take up all the lift space and it's going to just be possible for other people to ride in the lift with the dog, or it'll make it extremely uncomfortable for people to do so. What does the committee do? And my answer is this. You have to have a good or sound reason for rejecting that pet application. Saying we do not want pets in our building, this is a pet-free building, is not a good reason. If that's the reason the committee rejects the pet application, then the owner or tenant will be entitled to challenge that decision in NCAT and they'll win. Saying, for example, we don't want large dogs. Large dogs aren't suitable for our building, full stop. Again, that's probably also not a reasonable decision because it may well be possible for a large dog to live in an apartment building in a way that doesn't have a detrimental effect on the amenity of other residents. So the committees need to be a bit smart about this, leave their emotion at the door, think about it rationally, and think, is there a good reason for us, viewed objectively, to reject this pet application? Now, what would be some good reasons? Well, if there's evidence that this dog, for example, used to live in another apartment building and attacked a resident in that building, barked throughout all hours of the day and night and caused a general nuisance, then you would have a good reason to reject the application for permission for that dog to be kept. If there was other evidence about the problems that pet had created elsewhere or in your building, for example, if someone had brought that pet into the building illegally previously and then applied for permission to keep the pet, you could say, sorry, this pet has actually run amok. It has defecated all over the common property. It's dug holes in our garden. It's barked from your balcony while you're at work. That's a sensible, reasonable basis to knock back the application to keep that pet.
And how about number of pets?
That's also a grey area. So I do a lot of bylaws that say, if you want to keep more than one pet, we can knock you back. And it's reasonable for us to do so. And I think if that ever gets scrutinised, again, we're getting back into the territory of imposing a blanket ban. What we're really saying is there is a ban on you having more than one pet in your apartment. And I think if you look at what the court said in the Cooper case, that would not withstand scrutiny because it may well be possible for someone, a responsible pet owner, to keep 2 dogs in an apartment or to keep a dog, fish in an aquarium or a small budgie in a cage in a way that can't possibly have a detrimental effect on the amenity of other residents.
And I think we've covered the next one, but I'll just read it out anyway. When is it reasonable for an owner's corporation to refuse to allow a pet?
When that owner's corporation has an objectively good reason for doing so.
And the last one that we had written down that we had received in prior was, can residential tenancy agreements prevent tenants from keeping pets? And I think we've covered that one as well, have we?
We have, and the answer, at least in New South Wales, is yes. So it may well be the case that strata committees need to have a word to their owners to say, we like the way this building has been, no pets in this building, make sure your residential tenancy agreements don't allow pets.
Okay, now there are just a few that I had jotted down initially when we started, and we do have a lot more questions that have come in during the session, and we will go through the questions after the session and see what we can address. But just a few that I jotted down is, sorry, give me 2 seconds. One about visitors and non-residents. So visitors bringing pets to the building, and that might be in the form of visitors coming to visit residents that are in the building, or even short-term letting with Airbnb. And what are the rules around pets in those situations?
So the rules are going to be much the same. You're not going to be able to have a bylaw that imposes a blanket ban on visitors or guests bringing pets into the building. Again, why? Because it may well be possible for some pets to be brought into the building without creating problems for other residents. And if we think of some examples, we think about Hollywood, small little chihuahua carried in a lady's handbag. I know it's stereotypical, but that may well be a way that a guest can bring a dog into a building without having a detrimental effect on anybody. It's a bit of an extreme example, but that's just one. So no, you're not going to be able to ban visitors or short-term stay guests from bringing pets into the building. You're going to have to regulate it, and you're going to have to require them or the people they're visiting to get permission for them to bring the pets into the building, and you'll only be able to withhold that permission if you have a reasonable basis for doing so.
And we might just finish on a question that kind of flips everything around and looks at it from the point of view of a resident who's wanting to apply for a pet. Would they be best when they're putting an application in to have a pet overview and a bit of a pet resume from what the pet's like when they're submitting an application?
Absolutely, Nikki. You've got to put your best foot forward, as they say. So if you're applying to your strata building for permission to keep a pet, put your best foot forward. Provide as much information about the pet as you can. Go further than just saying, I want to keep a 13-year-old miniature schnauzer in my apartment. His name is Angus and he's really well behaved. Provide evidence that the dog is registered with the local council, microchipped, had its immunisations, is well behaved. Provide references, for example, from the dog's vet, from other people who have lived with the dog in the past. So if you're moving from one apartment building to another, get some references from former neighbours to say the dog is well behaved, it never created a problem in the 10 years that it lived in our building. It may well be that you want to bring the dog along to an interview with the strata committee. That does happen from time to time. You know, sit the pup on the desk and hope it behaves. That's the litmus test. So definitely provide fulsome details to your strata committee, because we have to remember this: if someone applies to keep a pet and they don't provide sufficient details about the pet, that may well provide a reasonable basis for the committee to reject the pet application. Because the committee might say, well, you just didn't give us enough information about this pet. We really can't make a properly informed decision as to whether the pet is going to be a good or bad thing for the building. Therefore, we're saying no. And that decision may well be upheld if it's challenged in NCAT.
Okay, thank you so much, Adrian. We might leave it there. I mean, we've covered so much information in that session in the hour. We're coming up to the end of the hour anyway. Once again, we've got so many questions in there, so we will go through and try and pull some of those out and get back to people about those. And thank you so much for your time today.
My pleasure, Nikki. Thank you for having me.
And thank you to everyone who attended, and the recording will go out as soon as we possibly can. We'll see you next time. Thank you.